All right. Well, hey, thanks for joining us. For those of you who have, it looks like there's a bunch of first-time participants on this call. Many of you joining us are members of your architectural committee, which is awesome. Appreciate having you on here and offering some education on just the different things that we need to know as we go through what is a very important process across most subdivisions in across the state is managing these architectural controls and making sure that we're following both the statutory language and also that of our governing documents. This is kind of part two of a two-part series. Maybe there'll be a third if we keep the interest going, but I know many of you are always very interested in learning more, and very thankful to have Clint Brown join us. Let him introduce himself in a second. Clint is a regular participant with on our webinars, and Clint, really appreciate your time today. Thanks for joining us.
Yeah, of course, Mitch. Thank you all for having me. And I'll echo Mitch's comment. I think that's awesome. We've got a bunch of ACC members joining us today because the law, as you'll soon find out, or you may already know, changed significantly this past year. And it's left a lot of ACC members and board members kind of scratching their head. So Mitch and I may have some solutions for y'all to think about so that you can more effectively manage your community and the architectural applications that come in. So I'm Clint Brown. I'm an attorney with Roberts, Markell, Weinberg, Butler, Haley. Attorneys like their names. That's why my law firm's name is so long. I'm board certified in residential real estate, as well as Property Owners Association law by the Texas Board of Legal Specialization. What does that mean? It just means I specialize in the area. I had to take a bunch of tests with the state bar. They rated me, and I got a good enough score to be admitted in those two specialty areas. So, you know, I'm going to give my attorney disclaimer.
Sure. Hey, before you do, just wanted to go over a couple of housekeeping notes.
Yes,
for those of you who haven't joined us on one of these in the past, we typically keep everybody muted just so that there's nobody accidentally hits the unmute button. We got all kinds of distractions going. So if you have any questions at all, please direct them in the chat. I'll be reviewing those along with Clint, and I'll be feeding those questions to Clint. So we'll also save a few minutes at the end. If there's anything that we weren't able to answer during the discussion, we'll make sure that we stop and catch up to all of your questions. So navigate to the chat and feel free to submit those questions, and we'll get answers back to you.
Perfect. Thanks, Mitch. And yeah, again, as Mitch, look, type your question. Mitch is good at interjecting kind of as we're moving through the slides, and Mitch and I'll kind of have a discussion on a lot of these slides we're going to be talking about here today, so that you get to hear the management company aspect of the issue as well as kind of legal aspect. And then questions from your board and ACC are going to help really move this PowerPoint along. So I really encourage the questions. It's going to help kind of get you the answers that y'all need when we're delving into ACC 201 here today. Again, I'm an attorney, got to give my legal disclaimer. So the information that I'm presenting today is based on the law as it exists today, June 17, 2022. And I'm presenting it for educational purposes, so it does not constitute legal advice. I understand that a lot of these, I'll put this in quotes, hypotheticals, may be real world situations that you're having to deal with. And I can appreciate that. And Mitch and I are happy to answer and provide thoughts and advice on it. But keep in mind that it is merely educational. We do not have your governing documents in front of us. I do not have the statutory guidance in front of myself either. So again, take the advice and the thoughts that Mitch and I give you for what it's worth. With that, let's go ahead and get in to today and what we're going to be talking about. So here's our source of authority to enforce our restrictions. And this is important for the ACC to understand, because a decision that you make as an architectural control committee has far-reaching consequences as it relates to enforcement by both your management team, Goodwin, and your board of directors. So we'll talk about this authority for enforcement first. And I'll do a quick sidebar. I'm going to use the term of art ACC throughout this topic. It doesn't mean that that is what your governing body is called for improvements. ACC stands for Architectural Control Committee. The state law calls it ARC, Architectural Review Committee. But your deed restrictions may call it a wide variety of things. Your deed restriction committee, your EDRC, anyways, various acronyms, they all mean the same thing. It is the committee that is created via your declaration that is charged with accepting, reviewing, approving, denying, or granting variances as it relates to improvements for applications in your community. So it's that body that is charged with reviewing improvement applications.
Hey, Clint, I did want to note, just to specify, most of what we're talking about today is really HOA subdivision based. So for those on the call that may be in a condominium setting, you're welcome to stick around and hear what we're covering today. There might be a number of things from a best practice standpoint that would be applicable, but note that when we're referencing the property code, and most of this discussion, I would say, is slanted toward HOA, subdivision, single family type communities.
Absolutely. And again, to Mitch's point, there's a lot of good best practice information in here, because the condominiums that you may be a part of now look like single family communities. And so the developer adopts a lot of the same processes that a single family community would have adopted. For those of you that are townhome board members, you may be a single family community, so bound by Chapter 209. You may also be a condominium community. So unfortunately, you've got to look to the documents to figure out what kind of townhome you are. But to Mitch's point, this information is going to be beneficial every time we make a statutory reference. However, legally, it only applies to single family kind of HOA communities. All right, so here's what the association, and it's really management, it's your Goodwin management team. This is the letter they have to send before doing these things. So before suspending an owner's right to use a common area like the pool, before the association's counsel can file a lawsuit against the owner, other than these two types of lawsuits: a suit to collect money, assessments, or foreclose on an association's lien rights. And then finally, you have to send this letter before you can charge an owner for property damage or levy a fine for a violation of the governing documents. So before you can do any of those things, you have to send what's called a Chapter 209 demand letter. It's 209.006 demand. And here's what the notice, that 209 letter, has to include. It's got to describe the violation or property damage. That is the basis of the suspension action, charge, or fine. It's got to indicate what the suspension action is, what the charge is, what the fine is if they do not cure the violation, and then state any amount that is due the association from the owner. And then it's got to give the owner certain rights, the entitlement to cure the violation, to avoid the suspension, charge, or fine, unless the violation is what's called an uncurable violation, and unless the owner was given a similar notice within the preceding 6 months. And then finally, they may get hearing rights under 209.007 as long as they request it within this 30-day period. And they may have certain special rights under the Service Member Civil Relief Act if they are serving on active duty for our country. So all things that are included, Goodwin is very good at following these requirements under 209.006. But, as this ties into the ACC, so if an ACC denies something and the owner constructs that something anyways, this is the letter that your association has to send by working with your management team. They may send a courtesy letter prior to this letter, or they may go straight to this letter. So this is something that your board and your management team has to do and comply with, assuming you deny an ACC application.
And this language is also largely included in every one of our violation letters and that type of correspondence across the board. So
perfect.
Covered on that end.
So the authority to enforce, again, 209.007 of the Texas Property Code, and it allows for this hearing before the board upon a timely written request. And that's it in a nutshell. So ACC does a denial. We're gonna get into the hearing for that denial in a minute, but you send a denial, nothing happens, but the owner constructs the improvement anyways. That gets to the board and Goodwin. And then the board has this enforcement obligation by working with the Goodwin team, and that letter gets sent. Upon expiration of that letter, if they still haven't taken down the structure or changed it as required by the board and or ACC, it gets sent to our law firm, and then we have to send our letters. And if it is egregious enough, we go back to the board of directors to consider whether or not to file a lawsuit for that violation. So that's kind of how the ACC and board interact as it relates to improvement requests that the ACC is charged with reviewing. Now, let's get into ACC. So kind of start to finish, we're going to talk about today. Here is the statutory guidance for ACCs. And again, they call it the Architectural Review Authority. We're still going to refer to it as the ACC because that's more of a common use term in our industry. And this is the new law that went into effect September 1st of last year, 209.00505. So the first headache that this new law caused prohibits a person from serving on the ACC or whatever it's called in your governing documents if the person is a current board member, a current board member's spouse, or a person residing in a current board member's household. So y'all know how big volunteerism is in a lot of your community associations across the state. And you've got people just knocking at the door trying to get in and commit their time to serve no, of course not. So the first issue we had was, well, we can't find anybody to serve on the ACC. So how in the world can we do this the right way? I'm a board member, I'm an ACC member, and we can't find anybody. What do we do? So the first thing you do is, again, push, try to get somebody on the ACC. If that doesn't work, another alternative you've got is in a reading of this statute. The statute is worded such that you can arguably overlap, so you can be a board member and an ACC member until the expiration of term for one or the other. And it is typically the board term. So you can wear both hats until your board term expires. Upon expiration, you have to separate it out and you cannot wear both hats ever again. That's an interpretation that I don't recommend using unless you're in the most dire of circumstances, because you don't want to have to argue that down the road if an owner wants to try to, bring a lawsuit and argue you did it wrong because you were wearing a board member hat and an ACC member hat.
But just to add to that,
keep in mind, this law does not apply to those communities with 40 or less lots and or during the developer period. So for those of you on the call who are currently in declarant control, developer control, this requirement doesn't apply to you yet. Now, the minute transition occurs, however, and developer kind of steps out, then it activates. So it's an important thing for you to be aware of.
Yeah, I was just going to add that as a result of.
All right. So again, what do you do? There's that overlap argument you can utilize. Again, worst case scenario. Another thing you need to consider is contracting with your management company. Mitch, are y'all offering that as an option for some of y'all's communities?
Yeah, I was going to add that. Can you hear me okay? Clint? You may not be able to hear me.
Mitch, you're on mute, sir.
No, I'm not. Can you hear me?
Okay, we may have lost Mitch. He's working on some connectivity issues here. Mitch, oh,
Can you hear me
I'm
okay?
sorry. I just can't hear you, Mitch. Go
Oh, okay.
go ahead,
Yeah,
sir.
sorry about that,
It's
Clint.
me.
Yeah, no, in response to, I got a lot of questions from our board members following the the legislative changes last year. And so one of the things that we've done is stood up a department that handles that effort, right? And so essentially what we've
I
offered.
apologize. Give me 1 second, everybody.
Yeah, no worries. Essentially what we've done is we've offered both a review and a full review and approval type service where we've got a team that is managing the application. So essentially you could delegate to the authority of the committee if you can't find volunteers to our team, and then they would put together a review and loop the board in on their review and their decisions. So just a thought, if anybody on the call is interested in learning more about that, I'd be happy to take that offline and offer more insight.
Perfect. Thank you, Mitch. Sorry about that issue on my end. So to Mitch's point, y'all have to take action. You cannot allow for your ACC not to be populated with owners, and if not owners, a professional company like Goodwin. So,
and Clint, point of clarification there, doesn't apply to condos?
It does not apply to condos, no.
Okay.
Very, very good question. Does not apply to condos. So again, board members for condominium regimes, you can still continue to wear both hats. You can wear the ACC member hat and the board member hat. And kind of going to the legislative intent here, the concern that they had is that they have a board member or members who are wearing both hats and just exercising too much control and not getting enough independent opinions and thoughts on applications and whether or not they comply with the governing documents. That was their argument. That was their concern that they had, and why they enacted this requirement. They didn't listen to us when we said that this is going to cause some problems for those boards and communities that just don't have the ability to get volunteers. Anyways, it got passed. It's the law that we're working with right now. All right, so ACC gets an application, reviews the application, and sends a denial. Previously, you could just send a denial, period, end of sentence. And if the documents didn't say anything on a right of appeal, that was it. ACC denied, you're done, and you move on. Now there is a statutory requirement for a right of appeal. Well, what if your governing documents have a right of appeal as well? You've got to do your best to read the statute and your governing documents together. If there ends up being a conflict between the statute and your governing documents, you are likely going to have to comply with the statute. So again, if you've got a hearing requirement for your governing documents, maybe get with your counsel or your Goodwin team to make sure you can read them together. And if there's a conflict, you've got to figure out which one controls. In your denial letter that must be sent to the owner, you've got to provide the notice of denial. You've got to include the basis for denial in reasonable detail. And if your denial can be converted to an approval, you've got to include the changes, if any, for a conditional approval. So you can either say this has been denied unless you do X, Y, and Z, or you could say this has been approved if you also do X, Y, and Z. So you've got to provide that to the owner. And you've also got to notify the owner that they have got 30 days to request a hearing in front of the board of directors. And it's 30 days from the date the notice is mailed to the owner. So 30-day period starts when the notice is provided. Notice is typically sent via email. I really don't have many regular mail notices that are currently being provided. It's an email notice, and it's gotta include all that information in there. Owner then has the 30-day window. Within the 30-day window, let's say it's day 25, they request a hearing. There's another 30-day period that activates. They've got 30 days from the request, the board does, to schedule that hearing with the owner. So 30-30, remember those two. They're very important to remember. We don't want to miss those timeframes.
Clint, just something to add. So for those of you who are utilizing Town Square's architectural review feature, if you haven't heard of it or haven't had a chance to review it, would certainly encourage you to do so. Helps make it much easier to streamline the approval process of architectural requests as they come in from the homeowner. It also allows us to deliver communication back to the applicant about their request, allows us to tee up whether it's approved, denied, approved with conditions. To Clint's point, one thing that's been pretty helpful that we've also added as just another form is we've added a hearing request form in many communities. So just to streamline the process of when a homeowner's request is denied, we never want to miss that hearing request. And so one of the things that we'll do is we can set up a little form, and that little form will say, will allow the homeowner to submit the same request the same way that it's submitted through the architectural review process. But that gives us kind of a time-stamped opportunity to note when that hearing request came in, and also allows us to get some additional information from the homeowner. So we can create a custom form, allows us to get the information from the homeowner and then submit the reason for the request so that we have some understanding of what is going to go into that hearing. Or if it's something reasonable, something simple, then potentially we could just avoid having to even go through a hearing process by reissuing a verdict letter with what the homeowner has requested in essentially an amended application.
And, you know, speaking kind of as an attorney, I'm a big fan of something like Town Square, because it really does organize the application and the denial. Because if push comes to shove and we're dealing with a $100,000 project and an owner's angry because, you know, you can't tell me what to do on my property, they retain an attorney who then goes after the association for the decision. I want a clean file, and Town Square allows you to keep your file very organized and very succinct, so that I, as counsel for the association, can step in. I've got a data set I can rely upon to adequately represent the association if that owner retains counsel. So great process to use if y'all use it.
One other thing to note, whether you're using SmartWebs as a tool, for those of you who are still using SmartWebs or Town Square, encourage you to look at customizing the forms. So, historically, communities have used one type of form for every single type of project that's being submitted. And so things kind of get lost in translation if, you're talking about the difference between painting a home and installing a pool. And so one of the things that this technology allows us to do is create kind of multiple forms, and allows us to create very specific questions for the type of project that's being submitted. And that creates a lot more clarity for the committee. It allows us to create required documents to support that application. Just gets very much more specific about the project, which avoids the back and forth with the homeowner, and ensures that we have all the information needed to make a decision. So for those who are committee members or board members on the call, just know that functionality is available. We are going to have another webinar scheduled at some point in the very near future to talk about, to just kind of offer another deeper tutorial about that tool specifically. And we'll get the invitation out to that shortly.
Perfect. Okay, so Bob, the owner, submits the application. The application gets denied by the ACC. The 30-day time frame activates. The ACC provides the proper notice, and Bob requests his hearing on day 25. The minute that hearing gets requested, the board gets notified through your management team, and they've got 30 days to respond. When they provide that hearing date, and again, let me go back a slide, its hearing must be held within 30 days after the date of the request. So 30 days to hold the hearing. We also have to give 10 days in advance of the hearing. So that means you only have 20 days, not 30, you've got 20 days to provide notice of the hearing. So again, 30 days to hold the hearing, but you've got to give 10 days advance notice. So we're talking a 20-day window. And then finally, each party is entitled to one 10-day postponement. So if the day before the hearing that we scheduled, the owner says, oh, I want to postpone, they get to postpone for up to 10 days. They get to use it once, but they get to do that. And then the board could postpone again. So, many times to get through all this muck and go around all these 10-day requirements, this, that, and the other, I like to get with or I recommend the association just to get with the owner, right? Get management to get with the owner and say, hey, here are 2 dates and times that the board is available to meet with you. Let me know which one works for you. And then they confirm a date, they confirm a time, and you go at it that way. Now, if that doesn't work, then you can just start doing the statutory, this is the date, time, and place we're doing it. Many times boards like to have these as part of a board meeting. So let's say the board meeting is outside the 30-day period. You can ask the owner, hey, our next board meeting is this date. Are you okay with us having it on this date and at this time? And if they agree to it, it is okay to go outside that 30-day window. But if they respond with, no, I want it sooner, then stick to the law, follow the law on the 30 days and 10-day notice in advance.
And I got a good question from a member of the audience. If the homeowner is bringing legal counsel to the hearing, is it advisable that you loop in your legal counsel? Do you need to stop the process and kind of go down that path and work through the association's legal counsel, or is it okay for you to proceed as normal?
Most of the time, I recommend the association's counsel be present at that hearing. They're still entitled to the hearing. They're entitled to have an attorney, but when they quote unquote lawyer up, you need to have your attorney present as well. There are instances I've seen where the board is maybe has a few attorneys that don't practice in the area and are familiar with evidentiary standards so that you don't say something you're not supposed to say. But most of the time I recommend having general counsel present. So if an owner just shows up with counsel without telling the board or its management team, I tend to recommend to just say, sorry, we can't have the hearing because we need our counsel present as well. And then you push it and you get to activate your 10-day postponement. But I would argue that we get to go outside the timing because they failed to notify us that counsel, their attorney, was going to be present. But very, very good question.
And I mean, just as a point of clarification, this doesn't have to be done in person. It could be done on a Zoom call. So
Correct.
It doesn't have to take too much time to do or facilitate. You can do it the same way that we've kind of been handling many board meetings and other meetings.
Yep, absolutely. Absolutely, Mitch. Okay, so we've met all of our timing requirements and the day of the hearing comes. The board needs to have quote unquote their hearing packet put together, all of the information that the ACC looked at in their denial. And then they basically meet with the owner and they allow the owner to kind of quote unquote state their case. We are not obligated to present our case in chief first. That relates to a different type of hearing that we're not going to be talking about today. That's a deed restriction violation hearing. We're talking about an ACC appeal hearing. And basically, we allow the owner to say their piece. If you've got multiple hearings that you're going through that day, you can do a timing limit that's reasonable. as long as you provide them with that timing limit at the beginning so they understand that they need to tighten their presentation if they have one. The board is entitled to ask questions of the owner if they've got questions, but I do not recommend you make any decisions in front of the owner. Why? You're not a board of one. You're a board of 3, 5, 7, 9, whatever the number is. And I can almost guarantee when you are making a decision in the meeting, it is a decision made by maybe 1 or 2 of the board members. And you're not allowing the board to discuss the issues openly amongst themselves after meeting with the homeowner. So do not decision make, listen, ask questions, and thank them for their time, and let them know that you will advise them of the board's decision within whatever time you think you need. It needs to be a reasonable period of time, though.
Clint, is there any reason why an architectural committee member wouldn't be able to join in on that hearing, even if just to offer their input or their guidance based on, you might have someone who's kind of a specialist and can offer insight as to why they voted to deny something a certain way?
Yeah, no, I have no issue with that at all, Mitch. I think it'd be good to have an ACC member there if they're free, as long as they understand that, hey, this is a decision of the board, not the ACC. Most ACC members respect that in light of the new law. But yeah, no, I think that's a great idea, Mitch. Absolutely agree.
And a follow-up to that, and this is one that I kind of hear often and wanted to get your thoughts on. Let's say one of the requirements of the ACC is that homeowner gets signatures of any neighbor on either side or behind, anybody who would be affected by, let's say, construction or the improvement in general, and they just want their sign off. Let's say that homeowner can't get the sign off, and so the ACC denies that application. What standing? I mean, what authority or power does that neighbor's signature have on such a request? Is that grounds to deny a request?
No, I really don't think it is. I understand the reasoning behind that neighbor approval idea, but the ACC doesn't make decisions on whether or not the neighbor is going to like it. The ACC makes decisions on the dedicatory instruments, on your governing documents. And by relying on a neighbor approving or disapproving of whatever the proposed improvement is, the ACC is, not following the rules it should follow on your governing documents. So I personally don't like the neighbor sign off. Again, I understand the reasoning. You want the neighbors to be happy with it, but again, it's not, are your neighbors happy? It's, does this meet the requirements of the dedicatory instruments? And if the answer is yes, then it should be approved. If the answer is no, then it should be denied unless you've got variance authority. And we'll talk about variance authority here in a minute, but I am not a fan of the neighborhood checkbox, the neighbor checkbox, excuse me.
Great.
And then finally, audio recording permitted by both parties. Mitch, you raised a good point on kind of ACC input for the appeals process. One other question I get a lot of is input from the board at the ACC stage. So again, we're going back to the rule where a board member cannot be an ACC member. Well, the next question I get from the board or the ACC is, hey, can we know about the application? Can we provide our thoughts about the application? And my answer is yes, you can know as a board member about the application. Yes, you can provide your thoughts about the application, but do not decision make. Do not decision make. Give the ACC your thoughts, maybe point them in the right direction for the governing documents. I get it. The board has an intimate knowledge of the governing documents, and you may have been a board member and ACC member for the past 15 years for your community, and you've got a lot of knowledge base, but you cannot decision make for the ACC. That is no longer allowed. But can you look at them? Can you interact? Yes, You just have to be careful, and you've got to do it the right way. And if you as a board member really want to stay involved on the ACC, and again, ACCs are very, very, very important, just resign your position as the board, as a board member, and get on the ACC, because ACC members and committees and decisions are still very important. They're one of the higher percentages of cases we see from an insurance defense perspective is an ACC case where the improvement was denied or the improvement was approved and the association gets sued because of it. So they are important. Just be careful with how you interact. Remember, you cannot decision make for your ACC any longer. And then finally, this is a governing document driven time frame, but many governing documents give the ACC a period of time to respond. Once all of the documentation has been provided, proper documentation, there's many times a clock that starts ticking. And if you do not respond within that clock time period, the ACC application can be what's called deemed approved. So you want to avoid those deemed approval situations. So please, please, please remember the clock to avoid these deemed approvals.
Yeah, I can't stress that enough. Especially when you've got a committee that isn't as engaged or may lose track. I mean, some of these, I've seen communities that have some really tight turnarounds, like 10 days. And, if somebody just stops paying attention for a little bit, it becomes really difficult, and you risk this idea that you might be automatically approving something if you're not paying attention to those timelines. So suggestion there in terms of those applications and the return time on those responses is incredibly important, and it's why software like Town Square Smart Webs is incredibly important to keeping that stuff organized and getting the clock running.
Yep. And look, if you're running up on the clock and you need more time, deny the application.
Right.
Just deny the application.
Yep.
If the application is incomplete, it's missing some core terms, you've got two options here. You can say, hey, the application is incomplete. We need X, Y, and Z by date certain, or it will be denied. As long as you're able to adequately monitor the date certain, so that when it comes and goes and they still haven't provided the info, you deny it, that's okay. But a lot of times I see these cases where you ask for more information, it was provided, it wasn't great, but we don't follow up. And then the clock arguably starts, and now we're dealing with a deemed approved issue for something that should not have been approved. If you're worried about that and the application is incomplete, deny it outright and say application denied because you didn't provide X, Y, and Z as required by the governing documents or the architectural guidelines.
So Clint, just to be clear, so there's essentially two sets of deadlines here for when an application is received. Some governing documents state that there's a period of time by which the association has to respond to that homeowner, or it's automatically deemed approved. So that could be anywhere from, I've seen a week to 45 days or 60 days. Many are silent on that. So I don't know, where you go with that, but for the most part, there wouldn't be a hard and fast deadline. And then from an appeals process, somebody submits an appeal and that request isn't heard. What happens then? Let's just clarify what the two different deadlines are.
Yeah, so if they submit an appeal request, and let's assume the governing documents are silent on the appeal process, so we're only relying on the statute. If the appeal timing isn't met, it's not a deemed approval, but the owner can bring a lawsuit against the association. Right. So again, still liability. So there's still teeth. So please follow the timing in that regard as well.
Yep.
Okay. So again, is there an architectural application involved that has been reviewed? These are all the terms of art for ACCs. I won't go into them, but you probably have an ACC that uses one of these acronyms. And again, here is the appeal to the association board. This is a section from a declaration that gives an appeals process. So you've got to try to read them together. If there's a conflict, the statute will likely control. And then here's another really, really weird situation. This is our laundry list of 15 items. And I'll do a quick sidebar on this laundry list. And again, to Mitch's comment at the beginning, this only applies to single family communities and townhomes that are designated as HOAs. And it's found under 209.0051H as in Harry of the Texas Property Code. And in a nutshell, H says, hey, the board can act outside of a meeting except for these 15 items. For these 15, you've got to have it at a properly noticed board meeting during the open session. And then here's your 15. And you go through it, you start looking at it, and then all of a sudden you see something, ACC Appeals. Well, wait a minute, ACC Appeals, isn't this something that should remain private because it's linked to the deed restriction enforcement activity of an owner? Because they're essentially violating the restrictions if they construct this improvement? I think there's an argument that the answer is yes, but then we've got this open forum requirement under 209.0051. So the next question is, can we have the 209 hearing privately, just between the board and the owner? And the answer is yes, I think you can, but there's a way you've got to do it. You've got to do it right. So 209.0051 also speaks to what's called an executive session. Y'all are probably familiar with that term of art. It's an executive session. It fits within your board meeting. So you've got your regularly scheduled board meeting. The board can adjourn the open forum portion or the open session portion of the board meeting and reconvene an exec. So it's within your board meeting. It is not outside. You cannot have an executive session meeting of the board. You can't do that. You've got to have a board meeting and then you adjourn into executive session. So keep that in mind. It is within the board meeting. It is not apart from the board meeting. It is a session within. And then you can consider this laundry list of items here. The last laundry list item that is highlighted is individual owner issues. So, and it's got to be done by a request of the party and agreement of the association. So what you can do in your notice of denial, so we're going way back to that notice that gets sent to the owner when the ACC denies the application. In that notice, you can say the 209 hearing will be held in private between the board and the owner unless you, owner, request it to be held during open session. So you say, we're doing it privately unless you request open session. If they request open session, legally, we have to have it during open session of a properly noticed board meeting. Period. End of sentence. But if the owner responds and agrees to whatever date, time, and place you set, we can argue, we have got a good argument that the owner has agreed to have it privately during executive session if we're dealing with a board meeting. So keep that in mind, but remember your notice, that denial notice needs to have that wording in there so that you're adequately protected from a 209.0051 perspective.
Hey, Clint, can we talk a little bit about variances and how that kind of factors into the equation?
Yeah, absolutely.
So first, I suppose it would be helpful to say, what is a variance? And it looks like you're getting to it. Perfect. Why don't we cover that aspect, because I saw some questions about it.
Yep. So new law came out last year on ACCs, and one of the subsections of that new law says the board can modify a decision of the ACC consistent with the declaration. That subsection, let's talk a little bit about, because prior to that law change, legal opinion was, in order to be able to grant a variance, you must specifically have the variance authority in your governing documents. So if your declaration does not have the authority to grant a variance, you can't do it. What is a variance? A variance really depends on what the document defines the variance as. But generally, a variance is a allowance that the board and or ACC can utilize to basically grant an exception to a deed restriction. So a lot of variances that I see in Goodwin, Mitch, y'all may see is, hey, the setback is 25 feet for improvements. We want to encroach 5 feet into that 25 foot setback. And the board and or ACC, assuming they have the authority, may grant that variance of encroachment. So that is the variance in a nutshell. What variances need to be considered. So let's assume we've got variance authority in our documents. The next question you've got to ask is, do our documents limit our variance to something that has to exist in order to grant a variance? Many of them do, but again, look at your documents. I'm giving a Ashford Place. It's a public document, section 1, but here is the wording that this board and architectural review committee have to consider in granting variances. So circumstances such as topography, natural obstructions, hardship, aesthetic, environmental, or other relevant considerations. So their variance authority is very, very broad stroke. As long as one of those laundry list of items exist, the Architectural Review Committee, the ARC, can grant a variance. In order for the variance to be effective, the variance must be evidenced in writing and signed by a majority of the members of the ARC. Now, what I do recommend on variances is if you grant a variance and it's a fairly big one, like an encroachment, I strongly recommend that variance be recorded in the real property records so that there is no ifs, ands, or buts, that the variance attaches to the property and follows conveyances from seller to buyer. So file those variances in the real property records, even if your document is silent as to that requirement. That is the governing document version of variance. The statutory version says, hey, the board can modify a decision of the ACC consistent with the declaration. So the question becomes, if we do not have variance authority, can we grant it via the statute? And I think I'm going to take the conservative attorney approach. I'm going to argue no, because of that last clause in that subsection, consistent with the declaration. So if the declaration has no variance authority in it, then how can the board grant it? So again, I could argue the flip side, but taking a consistent approach, that is an argument I would use, is we can't modify anything that's inconsistent with the declaration. Now, if we modify something that also is in line with the declaration, that is okay to do. And we can do that. And the board has the authority statutorily to do it. But if we have no variance authority, and it would be in violation of the declaration if we granted whatever the request is, then my argument or my recommendation generally is do not do it.
Clint, a question that came up earlier is kind of board member interference in a committee's decision. Committee, provides, approves a project. Board member or board members step in and say, whoa, you can't do that. Can a board overrule a committee's decision, even if the committee is adamant that, hey, we think it's fine?
Yeah, Mitch, this is a really tough one. So denial, owner gets a right to appeal, but an approval, we're not really activating the statute here because the ACC approved the application. So what do? It really depends on the egregiousness of the approval. Mm-hmm. I mean, if it's really bad and it is a clear black and white violation of the declaration and the ACC clearly exceeded its authority under the documents, I'm going to recommend to the board that they remove the ACC, they get a new ACC on, that denies the application, and you send a cease and desist letter to the owner ASAP, as quickly as you can, because you do not want the owner to spend funds in reliance upon the approval by the ACC, because that makes it harder for us to get the owner to stop. A lot of times we can look at the wording of the governing document and argue that the ACC is a separate body from the board, and the board is charged with enforcement of the restrictions, and we are enforcing the restrictions and telling the owner to stop, do not pass go, do not collect $100, because the improvement you're about to construct clearly violates article blank, section blank of the declaration. But man, it is a tough situation to be in, because you've got such a short fuse on those types of situations.
Yeah, it's not uncommon to see, especially since this is relatively new. Board used to have, used to handle all of the ACC requests, right? In smaller communities where they just haven't been able to put a committee together because there weren't any volunteers. And so kind of still involved in the process, maybe monitoring what's going on in Town Square, Smart Webs, as a request comes in and says, hey, committee, you can't approve this because of this, that, or the other. So inherently, there's kind of a little power struggle that might ensue in the event that the committee's adamant that this is something that's okay, and the board says, no, it's not okay, here's why, and they want to do it anyway. So it's kind of a tough situation, but I've seen it happen a couple times already where there's been some disagreement on the interpretation of the governing documents.
And so to Mitch's point on interpretation, look, declarations are subject to interpretation. That's why you got this guy. It's like, did the attorney draft this that way on purpose to stay employed? I don't know. Of course not. We draft it in order to try to hit as many circumstances as possible. But you give me a clause, I can come up with circumstances that make that clause ambiguous. So sometimes it's difficult to write in all of the hypos that are going to come down the road. And so what do you do in those instances? You, assuming you've got the authority, you establish architectural guidelines, right? That gives your ACC a rule book that they can follow. For instance, your declaration says an owner can install a shed as long as it's approved by the ACC. Well, what type of shed is going to be approved? Maybe you adopt a guideline that gives dimensions, height, material, placement, so that your ACC has a nice set of rules that are as close to black and white as they can be, so that we don't have these interpretation issues come up. And when you're designing these rules to help give clarification to your declaration, involve your ACC. It is so important for the board and ACC to kind of work together on rule promulgation, because it's going to help your ACC to want to work with the board down the road, so that we avoid that hypothetical that Mitch just posed, where the ACC does something wrong or there's a big argument between the ACC and board. So again, work together. Y'all are both in it for the same reason, benefiting your community, and you're both doing the exactly same thing, committing your time as a volunteer to ensure your community looks great for years to come. So y'all both have the same goals. So, do your best to work together.
Hey, Clint, just before we wrap, I wanted to make sure that we were, for those that were condo ACC committees, a little different set of circumstances. So just wanted to kind of make sure that we covered some of the nuances there in terms of what's different. So condos, lean on your documents, big part of that, right?
Yeah, absolutely, Mitch. So 100% for condos is document governed. We just don't have much in the way of statute unless the improvement or modification is going to be altering the structural integrity of the capital U unit. When that occurs, your condo really, really, really needs to get involved. But the general concepts that you and I are talking about, Mitch, variances, working with the board and ACC together, All those things apply equally to condos. The only difference is a board member can wear a board member hat
Mhm.
and an ACC hat at the same time if you're a condominium regime.
And yeah, and again, so those documents may be written in a way that's very similar to what we covered on the HOA subdivision side and hearings and everything else, but for the most part, you have a lot more flexibility in terms of how you manage the ACC process in a condominium. I wanted to note real quick about guidelines, incredibly important. Being able to provide your homeowners with insight on, you're saying that, and some of these documents are written in a way where like only, earth tones can be, you can paint your home in an earth tone. So what does that mean? Right. And so, does it make sense for a committee to come up with a certain set of paint codes that match trim and garage and that kind of stuff, roof color, probably a best practice there if you're going to get into, and certainly applicable to condos. Like the one big one that I see all the time on stacked units is soundproofing practices, right? If somebody's going to lay a floor down, before they can lay that floor down, here's the certain type of soundproofing that needs to go in to to make sure that we're not affecting the other neighbors. And so some of that stuff is rarely included in the governing documents. So long as we're not in conflict with the documents, the more information, the more practical insight that you can offer and post on the website, post to town square, the easier it's going to be for a homeowner to follow and really avoid a lot of this back and forth on what's permitted and what's not. And certainly there's all kinds of examples on ways that what other communities have put in place, so you don't have to kind of start over from scratch. Speak to your community manager about some of these guidelines if you are kind of starting from the beginning, and we can offer a bunch of helpful examples that that might save you some time. One other thing I wanted to note as far as variances and maybe practices, we always see this, and kind of what leads to hearing requests or denials is homeowner says, knowingly is submitting something that they know is not permitted, but points the finger at the 4 other homes in the neighborhood who have the same type of shed. And so, 20 years ago, somebody fell asleep at the wheel and didn't, let some of these sheds or some other stuff go through, and we don't have a variance recorded or nothing to point to. So how do we handle that, Clint? What do we do in terms of this kind of grandfathered in stuff? What, how should a committee or a board handle those types of decisions?
Yeah, so Mitch, really good question. So the legal term of art is kind of a waiver or kind of estoppel or abandonment of a deed restriction. Let's assume we're a no shed community, to Mitch's point, and we've got 100 lots in the community. So it's a low lot community, and we've got 4 owners that have sheds. Again, previous board, previous ACC dropped the ball, and now a new owner wants one and says, well, these 4 owners all have sheds, so I'm entitled to one. That 4 converts to 4% of the community, and I would argue that is not a waiver of the restriction. So you respond with, look, previous ACC made a mistake. We're not making the mistake. This is a no shed community. You cannot have the shed, period, end of sentence, and you move on. So the sins of our fathers don't necessarily apply to the current ACC. Same hypothetical, except now we're dealing with 25 sheds in a 100 lot community. So we went from 4% to 25%. That's one that's a little scarier. I would advise the ACC that there's a very real risk that no shed restriction has been waived or abandoned. And when a waiver or abandonment takes place, it means that particular restriction can never, ever be used again, ever, period of it is end of sentence. Now, I also advise that it's a defense the owner has to raise. And there's a little bit of wiggle room in that regard. But generally speaking, the more waivers you see in the community, the higher the percentage and the higher likelihood of a waiver finding by a court. So you've got to be careful with that. And you've just got to make sure to follow those deed restrictions. Even if there's a few other homes that have a shed, for our example, you should still enforce your restrictions.
Very good. All right. Try to get to some of the questions that we may not have asked before we wrap up. And if anybody has any additional questions, please feel free to type them into the chat at this moment. Just so that everybody knows, I'll also share a copy of the of today's presentation and recording after our call today. So you'll have a copy of the recording as well as a copy of the PowerPoint presentation, so that if you missed any notes, you can quickly reference it. I'll also share Clint's information. I know Clint is always great about being open to taking phone calls and helping answer quick questions. Would love to offer some insight where needed. Can the ACC or board go back and ask the owners of the 4 sheds to remove them?
Yes.
Okay.
To require it? Likely no. There's
Okay.
something called the statute of limitations,
Right.
and it's the 4-year statute of limitations rule. Now, if the shed, you cannot see it from the front of the house, and the association never ever received a notice of violation from a neighbor of the shed, well, then I think you've got a good argument that the statute of limitations does not apply. Yeah, so again, get with your management team. They're familiar with what's called the discovery rule and the statute of limitations, and they may call on counsel to give a legal opinion as to whether or not you can either ask or force the shed to be removed. Very good question.
I guess the idea of whether or not the association's made aware of something is always tough, especially when these improvements are made in someone's backyard and we can't gain access to a backyard, right? So sometimes it just happens, somebody peeks over and says, hey, that shouldn't be there. And it's not something that's readily available. In many communities, the backyards kind of back up to each other. So, a board member or manager or anybody else wouldn't have been able to access that, the rear of that lot. And so we're kind of at the mercy of others to discover these items and see where we go from there. One thing, let's see. So just for clarity again, 4 sheds, been there for 20 years. Is there a benefit or a need to record a variance for those sheds?
I don't know that there's going to be much of a benefit in that 20. If we're dealing with a shed that's been up for 2 years and the board or the ACC approved it in clear violation, then I think a variance may be warranted. But yeah, the 20 years, I don't know that a variance is going to be warranted, Mitch.
And is there a way where we would, if we were recording a variance, let's say somebody mistakenly installed the wrong roof, and we didn't want to make that homeowner tear that roof off because of the cost involved, right? So, is there a way that you create a contract with that homeowner to say, hey, before you ever sell it or the next time you have to replace that roof, it's got to be compliant?
Absolutely. So it's a kind of a conditional variance, and it gets recorded in the real property records. I think this type of variance is super important to get recorded. And you basically say, hey, we're going to allow you to keep your brown roof, even though black is required, until one of the following events. Property damage where the roof is partially or fully destroyed, any roof replacement must be black, or you sell the property. Prior to sale, you've got to replace the brown roof with a black roof. And you get them to sign it. You get the owner to sign it, and then the ACC and or board signs it, and then you get it recorded in the real property records. That creates this contractual obligation to Mitch's point, but then also creates a document that runs with the land, so that when they do sell it 15 years down the road, title's going to notice this variance and is going to say, hey, you've got to change your roof color. So it protects the association down the road.
All right. Try to get to a couple more questions here before we wrap. I appreciate those of you who have stayed on the call. Is the ACC required to entertain input from owners regarding violations or issues? I would say typically not the ACC, the audience to that. I think that's more better submitted to management and the board, and something that's discussed at board meetings. I wouldn't put the ACC in a situation where they're having to receive feedback or complaints, on things. Try to keep that as anonymous as possible. That's why, submitting requests like that via Town Square or directly to management, and then allow us to work with the board privately to deal with that. The less people that know that, the better, I would say.
Absolutely agree, Mitch.
Question, because this might be a good question. So what does it mean to get something recorded in the real property record again?
Yeah, so, the county where your property is located, they keep a record of documents that concern real property in that county. And so when you record something, let's use a variance as an example. The county, we'll say Williamson County, they take that variance and they bind it to the particular piece of dirt in Williamson County, Lot 1, Block G, Phase 2. And it attaches to the dirt, and it follows the dirt in perpetuity from owner to seller, owner to seller, owner to seller, forever, unless and until the variance gets released by the entity that filed the variance, i.e. the association. It's important because, statutorily it says when you file it in the county records, it is noticed to the world, to the public, that there is this thing affecting title to the property. Number one. Number two, it's important because title picks up on these. Title does their real property analysis. They look at documents attached to that Lot 1, Block G, and it puts the buyer on specific notice, actual notice, because title says, hey, here's some stuff we found that you need to get taken care of, buyer or seller.
A lot of interest on the variance conversation. So let's say a board goes out and does an audit of the community and says that there's 10 roofs. They don't know when they were installed, but 10 roofs that are very different in color than, the other 90 gray roofs in the community. What's the how far can you go back and maybe submitting that agreement with the homeowner via a recorded variance to say, hey, we're gonna issue this variance on your roof. Don't know much of the details, but know that the next time you go change it, or can you condition it on when you go sell your home, we need that changed back to a different color.
Absolutely. Do your best to work with the owner. In terms of wording on the notice, it can either be a violation notice, hey, you need to change your color, and then they get upset and contact you and say, look, we'll agree to allow you to keep it as long as you agree to X, Y, and Z. Mm-hmm. You ink it and you're done. But yeah, no, doing your best to work with the owner to get a variance recorded and them to agree to change the color back when certain events happen in the future.
What is reasonable in certain events? Is it the replacement or is it upon sale? Can you actually condition someone that before that lot changes hands, you got to replace the roof?
Absolutely. Right. You can get them to agree to that. And then again, property damage where the roof is partially or fully damaged. Those are two of the conditions that I do my best to include into a variance.
Got it.
And look, we may be in a stronger position. We may be in a weaker position. If we're in a weak position, then maybe we've got to leave one of those conditions out.
And to be clear, these variances can apply to condos as well.
That is correct. Absolutely.
Yeah, so probably get a lot flurry of activity on that. And I'm sure there's a lot of folks with sheds that want to get something on record with a homeowner to say, hey, keep your shed, but the day you go sell your unit, you need your home, you need to pull that shed out of there.
Well, and condos are really unique, Mitch, because, all condos that at least I've dealt with have impervious cover limits on percent.
Hmm.
So literally, even if you've got a nice big backyard, you may be at your impervious cover limit such that you cannot put one additional impervious square foot in your backyard. Impervious basically means water cannot penetrate down to the soil, and impervious cover limits are designed to prevent too much runoff into neighboring areas or drainage detention ponds.
I guess I would note that that's probably most impactful in Austin. I don't run into a lot of that in Houston or Dallas, but I know the municipalities are very, very strong on that, and that the association as a whole may have limits. So it's something that the ACC has to kind of manage to say this is all that you're responsible for, and a certain percentage of what anything can be put on a lot within the community.
Absolutely.
Very tricky one.
Yeah, the single family condominium regimes that you see that can have improvements.
Mhm.
I've never seen one not in city limits, right? Because they do it because they want to tighten up those houses, and the only way they can tighten them up sufficiently is by making them units.
Right.
Yeah.
Wild. All right. Well, for the purpose of time, I hope we got to most of your questions. But I will say, if there's anything that we didn't get to, please feel free to respond back to the recap email that should go out either later today or tomorrow morning, as soon as I get the recording ready for sharing. So please feel free to reach back out to us and let us know if we can help answer any questions, and look forward to connecting with you at that time. Clint, thank you. Appreciate your time today, man.
Hey, absolutely, Mitch. Thank y'all for having me, and y'all enjoy your weekend. And if you're a papa, happy Father's Day.
Clint, where can they reach you?
Robert's Markel, Weinberg, Butler, Haley, and my email is C as in Charlie, Brown like the color, and then it's at that acronym, so RMWBH.com.
Awesome. Thank you, Clint. And again, we'll share your contact info in the recap.
Absolutely, Mitch. All right.
All right.
Everybody.
Thanks all.